Is it legal to fire someone by text or email? Picture this. You wake up, check your phone, and see a text or email from your boss saying, "We no longer need your services." No meeting, no phone call, just a short message ending your job. You're stunned, maybe angry, and you wonder, is it even legal to fire someone by text or email? It feels cold and unprofessional, but legality and fairness aren't always the same thing. Under U.S. employment law, many workers are employed at will, which means termination can happen suddenly. But even in an at-will system, the method of firing, whether face-to-face, by letter, text, or email, still raises legal questions. In this video, we'll break it down step by step. What at-will employment really means, whether digital firings are legal, what limits apply under discrimination and retaliation laws, how state rules differ, and what rights workers have when a firing is delivered electronically. At-will employment. The baseline rule. Most workers in the United States are employed under the at-will employment doctrine. That means employers can terminate workers at any time, for almost any reason or no reason at all, so long as the reason isn't illegal. At-will applies regardless of the method. Whether the employer calls you into the office, mails a letter, or sends a text, the law generally views all as valid ways to end the employment relationship. Example: a retail employer sends a text firing an employee after a slow sales month. It may be harsh, but unless the firing was discriminatory or retaliatory, it's legal under at-will employment. Professional versus legal standards. There's a difference between what's professional and what's legal. Most HR experts say firing by text or email is disrespectful and bad for morale. But the law doesn't require professionalism. The law cares only about whether the firing violates specific statutes or contracts. Professional norms suggest a face-to-face meeting. Legal standards allow termination electronically in most cases. Courts rarely intervene in how a firing is communicated unless rights are violated. Example: a manager fires an employee by email with no explanation. It may be unprofessional, but if no discrimination or retaliation occurred, it's legal. Exceptions: contracts and handbooks. Some employees are not purely at will. Employment contracts, collective bargaining agreements, or detailed handbooks may require certain procedures. Contracts may require written notice, meetings, or progressive discipline. Collective bargaining agreements often outline termination procedures. Employee handbooks, while not always binding, can create enforceable expectations in court. Example: a union contract requires a termination meeting with union representation. If the employer fires by text without that meeting, the firing may violate the contract. Discrimination laws. Limits on how firings happen. Even if firing by text is legal in general, the reason for the firing may be illegal. Title VII of the Civil Rights Act. Employers cannot fire based on race, sex, religion, or national origin. ADEA. Protects workers over 40 from age discrimination. ADA. This protects workers with disabilities from being terminated without reasonable accommodation. Pregnancy Discrimination Act protects pregnant employees from targeted terminations. If a firing by text is used to hide discriminatory motives, it may not stand up in court. Example: an employer texts a pregnant employee telling her she's no longer needed. If the timing suggests the firing was based on pregnancy, that violates federal law. Retaliation protections. It's also illegal to fire workers in retaliation for asserting rights. Filing a safety complaint under OSHA. Reporting wage violations under the FLSA. Joining or discussing unions under the NLRA. Filing a discrimination complaint with the EEOC. Example: a worker emails HR about unpaid overtime. Days later, they receive a text firing them. Even if at-will applies, the firing may be unlawful retaliation. State law differences. While federal law allows electronic terminations under at-will employment, some states add extra protections. California requires final pay immediately if an employee is fired, regardless of whether notice is given in person or electronically. New York. At-will applies, but employees may pursue wrongful termination claims if discrimination or retaliation is involved. Montana. The only state that generally requires just cause after a probationary period. In Montana, firing by text could be challenged more easily if no valid reason was given. So, while the method itself is rarely restricted, the surrounding obligations, like final pay or notice requirements, can vary by state. Electronic records and proof firing by text or email creates a paper trail that can help in disputes. Courts may use the digital message as evidence of timing, wording, and intent. Example: an employer texts, "We're letting you go because you're too old for this role." That message is clear evidence of age discrimination under the ADEA, so while texts can feel unfair, they sometimes help employees prove illegal motives more easily than verbal terminations. Real-world cases. Case 1. A restaurant fired several employees by group text. Workers claimed discrimination when only women were targeted. The text became key evidence under Title VII. Case 2. A delivery driver was fired by email after requesting medical leave. The court ruled this violated the ADA because the firing was retaliation for seeking accommodation. Case 3. A retail chain fired staff by text without final pay in California. Workers recovered waiting time penalties for delayed checks. Case 4. In Montana, a worker fired by email without cause after probation sued under state law. The court ruled the employer needed just cause. These cases show that while the method of firing is rarely the issue, the underlying reason and legal obligations matter a lot. What workers can do. If you're fired by text or email. 1. Save the message. It's evidence of the timing and reason if given. 2. Check your final pay. State laws may require immediate payment. 3. Consider the reason. If discrimination or retaliation seems likely, you may have a legal claim. 4. Review contracts. If you had protections beyond at will, the firing may violate them. 5. File complaints. Contact the EEOC, OSHA, or state labor agencies if your rights were violated. Example: a hotel worker fired by text for complaining about safety violations files with OSHA. The agency investigates and orders reinstatement with back pay. The bigger picture. The law doesn't regulate how respectfully an employer communicates termination. It regulates why and when. Being fired by text may feel unprofessional, but what matters legally is whether the firing violated discrimination laws, retaliation rules, contracts, or state protections. In a digital world, texts and emails are becoming more common in employment decisions. Workers should focus less on the method and more on whether their rights were respected. So, is it legal to fire someone by text or email? In most states, yes. Under at-will employment, employers can fire workers in almost any manner. But the reason still matters. Firings based on discrimination, retaliation, or to avoid paying earned benefits are unlawful, regardless of whether the message comes in person or digitally. The bottom line, the method may feel cold, but it's the motive and aftermath that count. Save any electronic message, check your pay rights, and know that texts and emails can actually strengthen legal claims by documenting what happened. If this video helped clear things up, share it with coworkers. Knowing the difference between unprofessional and illegal helps workers protect themselves in today's workplace.